Good morning. It's the appointed time. We have a quorum. I call to order the meeting of the subcommittee on 6 pieces of subsidiary legislation relating to the implementation of the uncertificated securities market regime. First of all, I would like to welcome representatives of the administration in attendance. We have Mr. Francis Ho, Deputy Secretary, Mr. Larry Chun, Principal Assistant Secretary, Ms. Carol Lam, Senior Government Counsel, Mr. Jonas Wong, Government Counsel, and Mr. Rico Leung and his team from the SFC. Since the last meeting, we have received a submission. The submission has been forwarded to members. We have also asked the administration to provide a response, and the response, when ready, will be sent to members. Since the last meeting, members has raised some concerns. The legal advisor would like to address some of members' concerns. Thank you, Chair. At the last meeting, members raised concerns on LN 15 for Section 2. In the interpretation, there are some issues. I hope that with a document, we can provide some references. So say for notes, in accordance with Section 13 of Schedule 1 of the SNF Ordinance, it says specifically notes have no binding effect. As for Section 12, Section 13 would also apply in the SFO. So basically, the note in LN 15 would only be for reference. It has no binding effect. Next, on examples, whether they are binding. For Section 13 of Schedule 1, it only clarified the legal status of notes. It did not say anything on the examples. When no applicable provisions apply, examples would be seen as regulations and rules. They will have the same binding effect as provisions, and the SFC said they have nothing to add. And whether the examples are exhaustive. In an authority, it said that examples are not exhaustive. So this is just for reference of members. Thank you, Assistant Legal Advisor. Let's move on to the clause-by-clause examination. We have at last meeting, we were up to Clause 2 of LN 15. We will start from Clause 3 today. If members wish to ask questions, please press the Request to Speak button. I'll assign a 4-minute time limit. Later on, when we scrutinize the 4 other pieces of subsidiary legislation, that are amendment subsidiary legislation, we will refer to the marked up copies, CB brackets 1371 brackets 04 to 07. Before we start, I would like to remind the administration and the SFC representatives to go through the clauses clause by clause. You may not need to say everything in each clause, but if members have raised concerns on a particular clause, you may elaborate. All right, administration, please.
So last time we completed the clause-by-clause review up to the end of Clause 2, so I will start from Clause 3, which is the clause on evidencing and transfer of title without instrument. So the reason for this clause is because there is a provision in the primary legislation, Section 101 AAC, which talks about how securities may be evidenced and transferred without instrument, and it refers to this being possible in the manner that's set out in the rules. So this Clause 3 is intended to supplement that one. And essentially, it says that for evidencing, it would be by a record in the Register of Holders, as described in Rule 11, which we will come to in due course. And for the purposes of transfer, it will be by a specified request that complies with Rules 13 or 14. And again,
好，我哋時間交俾江玉峰議員有個提問。
係主席，
Sorry, Ms. Doreen Kong has a question. Please pause here. I want to ask about Section 101 AAC brackets 1. Will it be included in an amendment? Because I refer to the existing ordinance, there is no such section. I also want to ask for prescribed securities. Ms. Mukadam explained last time for prescribed securities and participating securities, there are differences, and Ms. Mukadam has explained the differences. I understand what it says, but then for prescribed securities, there should be more than that for participating securities. So do we have a definition for prescribed securities? Thank you, Chair, SFC.
So the first question was whether 101 AAC is in the current legislation or is in the amendment ordinance. So it is actually in the amendment ordinance, and it will come into effect together with the entire USM-related legislation. The second question was about the definition of prescribed securities and participating securities. So the definition of prescribed securities is actually in Schedule 1 of the SFO. Well, we're going to add it by way of the amendment ordinance. And if you look at Schedule 1, the addition there, it links back to Section 101 AA, Section 101 AA, which is the heading of which is what are prescribed securities. And the definition there is basically it's securities which fall within a class of description specified in Schedule 3A. So Schedule 3A, again, is a new schedule that is added by the amendment ordinance, and also which are listed or to be listed on a recognized stock market. So that's the definition.
OK， 好，唔該主席，即係有。
Thank you. So there will be a definition, and I will rest assured. We have another member who would like to ask questions, Ms. Khan. Thank you, Chair. Like Ms. Doreen Kong, I would like to raise questions on Section 101 AAC. How will they prescribe the rules? So in the amendment ordinance, it will appear. It will be elaborated on. If the section is in the existing legislation, I would like to raise concerns as to whether we should draft the provisions this way, whether we need in existing ordinance a paper instrument. If we are to amend this with subsidiary legislation, is it feasible? But if your existing ordinance will be amended, I think we should refer to the existing ordinance. Anything to add?
Section 101 AAC, we have actually amended the substantive provisions of, say, the company's ordinance, the stamp duty ordinance, and for the fund companies, we'll be amending the rules that's part of the subsidiary legislation. So for the companies, there's a section in on transfer, which currently talks about transfers having to be by way of an instrument of transfer. Exactly. So we have amended those provisions to say that they can be by way of an instrument of transfer or a specified request, and then that provision is again linked to the subsidiary legislation. So those amendments to the company's ordinance, and there's an equivalent amendment to the stamp duty ordinance for unit trusts, units in a unit trust. So those amendments were passed as part of the amendment ordinance. So they are already there, and that ordinance has been enacted. But I can take you to the relevant provision if you would like.
主席你認為？
係咪我理解即係喺2021年？
So I understand that it was enacted in 2021. That has been dealt with. But can we refer to the provisions now?
For the CO, for the company's ordinance, you can look at So if you, I don't know if you have the amendment ordinance to hand. So it's Section 33 of the amendment ordinance, which amends Section 150 of the Companies Ordinance. And the amendment to Section 150, subsection 1, splits the original provision. So the original provision talks about the need to deliver a proper instrument of transfer. So that provision has been amended to be split into two parts, one dealing with shares that are not prescribed securities, so shares that are outside the universe of USM, and then that will continue to be just requiring an instrument of transfer. And then there is a second part which talks about where the shares are prescribed securities, and then what is required is either a proper instrument of transfer or a specified request.
Chairman, I would like to seek the Assistant Legal Advisor's clarification. It is said that the legislation has come into effect, but then it seems not to be the case. Assistant Legal Advisor. Well, in the Securities and Futures and Companies Legislation Amendment Ordinance, it was enacted in June that year. As the SFC representative said, a legal framework has been put in place. So the provisions are already found in the Companies Ordinance and the Securities and Futures Ordinance. We will deal with relevant subsidiary legislation on this occasion that would spell out the specific rules. So the provisions have been dealt with in 2021, but we are discussing the implementation details on this occasion. All right, this has facilitated my understanding because I was not a LegCo member in 2021. I didn't know that it was already amended, but now it has been 4 years that we are amending the subsidiary legislation. Well, anyway, I understand. Because if we don't refer to the principal ordinances, it would be confusing for me. Thank you, Mr. Rincon. I want to ask the Assistant Legal Advisor, can you repeat what the 2021 ordinance is? Thank you. The Ordinance is Securities and Futures and Companies Legislation Amendment Ordinance 2021. It's Ordinance number 17 of 2021. It came into effect on 11th of June 2021. It has yet to come into effect, actually. It will come into effect by notice in the Gazette. Oh, right, it is uncommenced because I can't see that in the principal ordinance at the moment. I don't see Section 101 AAC. Thank you for your clarification. So we have been looking at Section 101 AAC and the definition of prescribed securities. So it is in that ordinance. Right. Will this commence at the same time as these pieces of subsidiary legislation at the same time? SFC.
At the same time, the entire regime.
Okay. Thank you.
好，證監會可以繼續。
Sorry, just
FSC representative, please continue.
see it. Okay, I take it that clause 3 is okay, so I proceed then to clause 4. So this is the clause which explains what participating securities are. And as mentioned when we were talking about the definitions provision, this is an important concept in the USM rules because it is the participating securities which are securities that will that investors will be able to hold and transfer without paper documents. So because of the importance of this concept, it's important to be very clear as to when securities become participating and when they cease to be participating. And so Rule 4, Clause 4 primarily seeks to do this. So if we look at Clause 4.1, essentially, Clause 4.1 says that prescribed securities becomes participating securities on their participation date, and they cease to become participating securities when they cease to be listed. So the reason for them to cease to be participating when they cease to be listed is because once they cease to be listed, they will actually also cease to become to be prescribed securities. Moving
可唔可以
then.
停一停？
Sorry.
江玉歡議員係。
Can you pause here, Mr. Rincon?
Chair, for 2B1, if I may ask this question, you talked about the UNSRT system. That's fine with me. But I just want to know why you don't talk about the corresponding UNSRT system. And you simply mention UNSRT system without qualifying it with corresponding. Maybe it's in 2.1. You haven't defined that. You only defined corresponding UNSRT system. Another question, approved registrar. Do we have a definition where?
So the first question is why there is no reference to a corresponding UNSRT system, because there doesn't seem to be a particular need for it. The provision here talks about the participation date not being earlier than the date on which the issuer has taken certain steps. And those steps at that point would not necessarily tie with any particular UN SRT system. So the concept there is that the issuer must find a system, so to speak. And when he has found that system, then, because the paragraph 2, it talks about the approved securities registrar, so the approved securities registrar would provide the connection to the UN SRT system. Because if you look at paragraph 1, it talks about a UN SRT system operated by an approved securities registrar. So when it is the approved securities registrar, it follows that the UN SRT system is one that is operated by that ASR.
主席，我有追問，對唔住，我完全 with respect。
I have a follow-up question. With due respect, I can appreciate the point made by Ms. Mercado, but then in our laws, we must have a definition. Your explanation is good. I can fully understand it. But then without a definition, I find it difficult.
System.
In the
primary-
2021 ordinance,
in the 2021
right? Oh, very
ordinance,
good.
yeah.
And how about the approved securities registrar?
Fine. 咁嗰個核准嗰個咧，都係喺嗰度。
OK， 可以繼續。證監會。
Right. So, so moving then to subclause 3, which is the definition of participation date. So it essentially the participation date is the date that is published under Rule 2A, which is the date that the issuer publishes as being the date that it becomes a participating, that its securities become participating securities. So this obligation to publish will be set out in the listing rules. So the issuer will have to publish a date in accordance with the listing rules. If I may then move on to Clause 5. So maybe just before going into Clause 5, I just give an overview that the next sections deal with a separate part, which is the part on the register of holders. So a number of these provisions we've actually drawn by reference to equivalent CO provisions, but taking into account the particular needs of the USM regime. So starting first with Clause 5, which is the obligation for the issuer to keep a register of holders. This clause is cast broadly by reference to Section 627 of the Companies Ordinance, which imposes an obligation on all Hong Kong companies to keep a register of members. So subclause 1 essentially says that the register can be in English or Chinese. Subclause 2 talks about what the register must contain. So it's the usual things like name and address, the holder, when the person becomes a holder and when they cease to be a holder. Subclause 3 is the unique one for USM, because what we require is that the register of holders must also include, must also indicate whether the securities in question are held in uncertificated form and how many securities are held in uncertificated form. And the reason for this is so that there is a clear record in the register of members that particular securities held by particular members are in uncertificated form.
係我哋
All right. Mr. Johnny Ng, you have a question? Yes. For the registrar of holders, you only need the names and addresses to identify a person. Would that be sufficient? Because there may be false addresses. Do we need numbers of certain identification papers, etc.? In the past, we used to have a title instrument, but now there won't be any. Maybe it's there somewhere in the bill, but I'm not sure.
So we did consider that as well, about the need for personal identification information. We do need personal identification information for the purposes of the ASR to operate, to carry out its functions. But we do not think it's appropriate to include it in the register, because the register is open for public inspection in many cases. That's the main reason. But the share registrar, the ASR, will have that information, and that information will be very important for it to ensure that securities are passed to the right person when it effects transfers. And when transfers are effected, there will be, in the message, there will be sufficient information to clearly identify who's the transferor and who's the transferee, so that there is no misunderstanding. It will not be relying just on the name.
OK，下一位
Next, Mr. Tan Yueheng. Thank you, Chair. In relation to the issuers register, that's about a register of holders. In other words, holders are holding the shares. When somebody is no longer sharing the securities, this will happen when there are daily tradings. In other words, there will be changes every day to record the changes in the holders. In other words, the issuer at the end of the trading hours will need to make changes. So is there a deadline for the daily recording of the changes? SFC, please.
So actually trading is separate from transfer. So when you trade on the stock exchange, you will settle within 2 days. You have a T+2 settlement cycle. So when you trade, you are trading securities that are already inside CCAS and already registered in the name of the CCAS nominee. So the register of holders does not record all of those transfers, because not all investors will be withdrawing their securities out of CCAS and registering it into their own name. So it's two separate things. The trading is a separate thing altogether from the registration of transfers on the register of members. I don't know if, yeah.
即係應該嚟講就係分開喺中央結算處理嘅，同埋非中央結算。
In other words, either it is centrally settled or not. So just now, I think we were talking about the daily trading. So it is in the form of nominees. And so there's no question of this in relation to the changes in the register. Ms. Doreen Kong. Well, I think Mr. John asked a very good question. Just now, Ms. McCardam gave an explanation. It is for public inspection, so there's no need for so many details. But then it comes to my mind that when you are at the land registry, even with the amendment ordinance, a lot will be included for inspection in the public record for land transaction, property transaction. We're talking about dealings in the assets. For land transaction, we have names, addresses, and identification details. So do you have a policy covering all? Is it all because you want to play safe? But what about the property owners? Does it mean that they are not secure in relation to the personal details? Now come to clause 5, when the issuer must enter in the register of holders the particulars required under sub-rules 2 and 3 as soon as reasonably practicable, after receiving sufficient information and documents to do so. So 5(5). In other words, what about the case in which not sufficient information has been received? I think from time to time you may not be able to get all the information needed. Now, Rule 8, it says that should a issuer contravenes sub-rule 1 or 5, there is an offense. But what about contravening sub-rule 6? Sub-rule 6 says that the information has to be kept for 10 years for the minimum, and that cannot be destroyed. What about if the issuer only keeps it for 8 years? There's no contravention of any rules, right?
Starting first with the question about the land registry. Like I said at the outset, these provisions are cast by reference to the company's ordinance. As far as I'm aware, company's legislation does not require personal identification information to be entered in a register of members. This is not only the case in Hong Kong, but also in the cases of other jurisdictions where we have looked at their laws. We haven't seen anything which talks about putting personal identification of the registered holder in the public register. I suppose it's a fair comment. Just speaking from my own personal view, my expectation is that probably transfers of land are just not as common as transfers of securities. So perhaps there is a greater need for public disclosure in the context of property. I'm just speculating. But the reason we have not included it in our legislation is because we have tried to stick as closely as possible to the company's legislation. We don't want the USM regime to be creating things or introducing concepts or introducing requirements or regulations which are not necessary to USM and which have much broader and fundamental impact. So for that reason, we have not included it in the ROM requirements for USM.
其他個
What about the other two questions?
The question was on subsection 5 and what happens if the information received is incomplete. The transfer request will be refused. That happens today as well. So for example, if a person comes along with an instrument of transfer, he doesn't come along with the correct number of share certificates, his transfer will just be refused. He will be asked to go away. And I think that's reasonable and acceptable. As to your question about the offense provision, why is it not an offense for subsection 6? So again, subsection 6 is based on the company's ordinance. I think the way I read subsection 6 is that it's a provision that doesn't require destruction, or it just permits destruction after 10 years. So actually the share registrar can continue to keep the records beyond 10 years. So your question is, what would happen if they destroy the records less than 10 years? We haven't made it an offense here, but I guess in practical terms, because the register of holders will actually be managed by the share registrar or the ASR, and the ASR will be regulated by us, and we will be able to take regulatory action against them if they breach any of the provisions where they are assisting the issuer in carrying out their obligations. But we haven't made it an offense for that reason.
主席係
係簡短嘅，已經過咗時。
簡短。主席，我想
Follow up, yes, be brief. I hope they will consider the case of including personal identification particulars. Nowadays, there are many fraudulent actions. What about having the first four numbers or first four digits of your ID card number? Because I'm not sure whether it will be affected by online scams. And then for the 10-year requirement, just now Ms. McCartan said that regulatory action can be taken if they speedily destroy the information. But then for the investors, for the consumers, there must be a reason for keeping it for 10 years. So I think you need to consider investor protection instead of leaving it to the SFC to take regulatory action. I think at least you must make sure that they have to know the duty to keep to the provision, and there must be an offense and penalty for that. So please consider that, SFC.
The next member. Thank you, Chair. I want to echo on the points made by Dr. Tan Yueheng. We know that for trading, and transfer of securities on register, they are two things. So trading T+2, whether it's CCAS or whether you are withdrawing from that, there will be a difference. But to facilitate providing different options for investors, we may not need one to withdraw securities from a nominee. So essentially, a nominee will not be holding securities. So in sub-rule 2, it will be the case that you would include the names. But say in the USM regime, if we are going paperless, we need to have a mechanism to see, for example, the number of units and the relevant information. Combining with what Dr. Tan Yueheng asked, after transfer, if we are to go with this mechanism, well, we need to read sub-rules 3 and 4 together. We have yet to talk about sub-rules 3 and 4. Can we talk about the operations? So if we are going to dematerialize or rematerialize the securities, what will happen in the register? I think the SFC representative can go on with the clause-by-clause examination while explaining this. Or Mr. Leung, you would like to provide some supplementary information. Ms. Kamen Khan talked about going paperless at the last meeting. We talked about how investors can hold physical securities still, but investors can, of course, also go paperless. If people hold uncertificated securities, it may be through two ways. They may go through an ASR and hold an account with them. They may also go through securities firms or banks to hold uncertificated securities. So within CCAS, securities will be uncertificated, and some of them will be held by investors through banks and securities firms. So in future, if investors hold uncertificated securities and they are within the CCAS, the transfer will not involve the change of name on the register. So that is how it works under the USM regime for uncertificated securities. So there are still two ways of holding securities under the regime. I thank Mr. Leung for providing clarification. So if one holds those securities directly or through securities firms or banks, what will be the difference? If they hold the securities themselves, the register of holders would show their names. But if they hold through securities firms, it would work just like what they do today, because in the register of holder, the holder would be the SEC nominee. So we do not need to show the names in transfers. Thank you. I think it is exactly why we need infographics, because it can be confusing. Legislation is just says this, but then it does not spell out how the legal title works if one holds the securities directly or through banks, securities firms. If they don't want to go through the SEC nominees, what they should do. And as we raise concerns on what will be seen on the register, the differences may not be obvious in legislation. As we see here in Sub-Rule 5, they do not say a specific period. They just say, as soon as reasonably practicable, the issuer must enter in the register of holders the particulars required. What the process is, I think we need to enhance public understanding on this. I agree. All right, we have Mr. Yim Kong who would like to ask questions. After that, we'll proceed with clause-by-clause examination. Mr. Yim Kong. Thank you. I can see in Rule 6, Sub-Rule 2, must give a notice containing information with changes in the register. And other would be by post. And it can be sending the notice in electronic form or in hard copy form by post. But in clause 5, it says that any sending the notice would be an offense. So if an address of a holder has changed, sending the notice by post may not reach them. So if we may need to change it not by post but by delivery, courier, because the post may be returned so that we know that the notice cannot reach the individual. Otherwise, there may be complaints. Can they explain the reason behind this? Thank you. SFC representative.
So this is actually an issue that's currently faced by share registrars as well, where the registered holders, they've moved on, but they haven't updated their records with the issuer. The share registrars are under an obligation. We have actually got a code of conduct, and we have updated it or amended it to bring it in line with the USM regime, and that code of conduct will come into effect when the USM regime comes into effect. And there are requirements under that code that deal with the ASR's handling of obligations that actually are imposed on the issuer. So one of the things that we have looked at is the issue about where the address is not up to date. We do require that the share registrars make reasonable attempts, but at the end of the day, there is only so much that they can do, because there are, in a sense, there are different kinds of complaints. There may be complaints from the person who's now residing in the premises where the previous register owner was, and they're complaining that they're getting all this material that they shouldn't be getting. And there may be complaints from the registered holder that, the address, although they've updated the address, they haven't received the material. So there are different kinds of scenarios, is what I'm trying to get at. And what we have required is basically the share registrar has to do what is reasonable and do what is what would be reasonable in order to make sure they don't create nuisance for, say, a new occupant of the address where the registered owner previously was. It is difficult, really, to be honest, to do anything more than that, because we do need to protect the interests of the registered holder as well. And like I said at the beginning, a lot of these provisions come from the company's ordinance. Your suggestion about sending these by courier or delivering it personally, there are some steps that the share registrars take. Whether they include using a courier, I'm not sure. But I would expect that any additional steps or any excessive steps would have cost implications for them as well. Ultimately, it's the registered holder's responsibility to update his particulars on the register. So I don't know if it addresses to some extent your concern.
但係 even 咧，你提供嘅個地址係冇錯嘅，但係咧。
I think it's right for one to change its address voluntarily, but then something may be lost by post. I have experienced that before. I have not received the requisite information. I needed to call them. So if you can deliver things by courier, it is not costly. It will also make sure something gets delivered. I think the administration may heed the suggestion. I think different members have raised similar concerns at different times, we can perhaps see if there's room for that. No, Chair, let me say this. If there is a contravention, it will be an offense. So say I am a holder. If you have not posted the information to us, how can you prove that you have sent it to me? If you have sent the information by courier, then you would have proof. So if one is disputing this, by having information sent by courier, that would be direct proof. I think we should be stricter with this. I think the administration notes the suggestion, and I think they can identify potentially any room for improvement. Let's move on to the clause-by-clause examination. Excuse me, Chair. Let's pause here. We have other members who are asking questions. The question actually touched on Clause 6. We haven't talked about this before. Let's let Mr. Chen Siu-hong ask the questions. Chair, I want to ask about Rule 5123. I am concerned from previous discussions. One may misunderstand. I think I would seek clarification on this. So for Clause 5, we say the issuer must keep a register of holders. And we have talked about having parallel certificated and uncertificated securities, and we need a register holders to be kept, and this may be an electronic register. And we have talked about in Sub-Rule 2, the register must contain the name and address of holders. So some are concerned if things are sent by post, what may happen. But going back to the intent, how are we going to make use of the register of holders for certificated and uncertificated securities within CCAS or not? We may have to go through the SEC nominees, and there will be a register anyway. But now, because we're going paperless, we have an electronic register, and we have heard the SFC representative say that we have referred to the practices of other jurisdictions. We would only have limited information on the register. It will not show the ID number, for example. But if we're going paperless, if we're going digital, for government services, we are already moving towards digitalization, just like our ID, I Am Smart, e-license. We are for all of them going paperless, including for the postal address. For example, if we apply for a license now, we only need to provide the email, and we'll communicate via email. So I think the example given would arouse concerns when addresses change and are not updated. There may be something that may happen. But for email addresses, since we are quite commonly using email, would you consider other forms of communication being included, say telephone numbers or email addresses? So it goes down to how the register operates. We need to make sure we reach the holders. We should not leave any information in here. We need to make sure we are retaining useful information, and the register is to be kept for 10 years. If one contravenes this, the punishment would be a fine at level 4. So we need to be prudent. We need to make sure it complies with the law and it is accurate, the information. So in the end, what the register serves for, we need to think about that. And while we're going digital, why not consider including email addresses as a form of communication means? Thank you. SFC representative.
Again, in fact, we will be asking registered holders to provide their email addresses. Perhaps maybe to step back a bit. So the provision here on register of members, on register of holders, is intended to cover all prescribed securities. And so it will be a process before the prescribed securities of all issuers become participating securities. It will also then be a process before all the holders of each security become USI holders. So we're talking about a situation where you have multiple companies with multiple different state of affairs. So what this section is trying to do is sort of put a bottom line requirement, if you like, and say, right, you have to have a ROM. The ROM has to have these minimum requirements set out in there. And when the securities in question are in uncertificated form, you must stipulate that clearly. And one reason for that is because the investor will not have a certificate. So the ROM needs to recognize that no certificate has been given to this investor. On top of this, there is other regulation that will support this regime, and we will come to it in due course, especially when we come to the ASR rules. Because the ASR rules are also supplemented by a code of conduct, which I was mentioning earlier. So we did specifically look at this question of email addresses. So what we are thinking, or what we have in the code now is that we will be requiring the registered holders who hold in uncertificated form, they have to provide an email address, because the intention is that everything should be as electronic as far as possible. We don't want a situation where registered holders are holding their securities without paper and transferring without paper, but everything else is still in paper form. So the idea is really to encourage and build in incentives that drive investors to using electronic means. Ultimately, if the investor does not provide an email address, there is nothing that the registrar can do. But for uncertificated holders, what they can do is that when they set up the USI facility, as part of that process, they will require an email address to be provided. So at least for that population of investors, that population of registered holders, there will be an electronic address communication, and that is actually the intention. So, which is also why here we talk about, sorry, I've got a bit lost on the pages, where we have the notices being, the option there being the notices, there being an option there for notices to be in electronic form or paper form. We need to leave the hard copy form there for the investors who have not yet dematerialized, because there has to be protection for them as well. So if they have not provided an email address and they have not dematerialized their securities, they should still be entitled to communication, and their communication would have to be by paper. There would be no other option. So that the requirement there is to recognize that, you know, if you can't do it electronically, you must still do it in paper form. That's the sort of thinking behind that provision.
Chair, a follow-up question. I think what we were told was that ideally an email address should be provided. However, I just want to know, you only talk about name and address. Can you not say name and address or email address? At least you give them an option. They can give you all the information, name, address, and email address. Can this not be considered? That is providing an additional element to be included. At the end of the day, maybe I just don't care where you live, as long as I can get hold of you through a communication link. Just like in the case of traffic offense summons or tickets, what I'm interested most is an email address so that I can get in touch with you electronically. So the main point is about communicating with them. So it isn't so much about sending out a physical letter. Many members were interested in the case in which the letter or the correspondence was not received. Well, I think we have been spending 8 minutes on this point. If I got it right from the SFC, the explanation is that as far as this part only is concerned, I think perhaps we are not going as far as what members have been advocating, that is fully electronical. But of course, there would be other measures to make sure that there will be easier ways to deal with it. Of course, we have to strike a balance. We have a transitional period, and in the market there are people who are having certificated holdings. They have physical copies of the shares, so you need to protect them. If they are not able to come up with an email address, or if they're not capable to go fully electronic, then we still have to cater for that scenario. I think that's the explanation given. Maybe we should move on, and we give the floor to Mr. Tan Yueheng. Thank you, Chair. In relation to the register of holders, we ask the issuer to keep a register. Now, my question is, can we have somebody else other than the issuer? You now talk about the issuer having the duty to keep a register. What about the issuer entrusting the CCAS to do it? Must it be the issuer, or can we ask a securities firm or a third party or an approved securities register to carry out this duty? I just wonder whether they will be more efficient. SFC.
In fact, the register of holders of a listed issuer is always kept by an ASR, SFC approved. Currently, they're called approved share registrars, and under the USM regime, they will be kept by the approved securities registrar. That provision or that obligation is reflected in the stock market listing amendment rules, which we will come to when we get to that amendment. But the intention actually is that the register of holders has actually got to be maintained by an ASR. When we say maintained, means updated and amended as necessary. So although the obligation on the issuer is the obligation to keep, that obligation cannot be passed because the register of holders belongs to the issuer, so it has to be the issuer that keeps the register. But the share registrar or the ASR, as an agent of the issuer, would be responsible for maintaining and updating the register.
有冇
Any follow-up, please? My question was, the issuer has got this duty, but in fact, perhaps a third party or a ASR can come to an agreement with the issuer, and then the issuer could have discharged the duty. Any supplementary answers from the authority? Mr. Leung? I'll try to answer the question. Well, for listed companies, they will appoint an ASR to keep a register, but then the duty, the obligation rests with the issuer. Now, if we say that it is when the ASR has got problems with keeping the register, can we say that the issuer has got no obligation at all? Of course not. The issuer has the obligation to keep the record, to keep the register. Though they can entrust the job with somebody else, but the duty, the obligation lies with the issuer. We will be regulating the ASRs. We do ask the ASRs to keep a register of shareholders. It is something very important. We can't simply say that the issuer can fire an agreement, contract out, so to speak, the duty to an ASR. Now we say that the issuer must have the obligation to do so. Next, Mr. Chen Xiu-hong, Chair. A quick follow-up or a quick question on 2 points. In the discussion, I agreed with you. That is, we need to keep two segments in parallel. There are certificated and uncertificated holdings. Now, we want to go uncertificated. So can you not say address or email address? So that either you provide a physical address or email address. Now, Chair, I come to another question. Now, we are working very hard on the cross scrutiny, and we've been raising questions with the aim of fine-tuning the legislation. Now, this is a negative vetting subsidiary legislation. In other words, at the end of the day, we can only say yes or no to the subsidiary legislation proposed. But what about our suggestions to fine-tune them? As everybody knows, the devil is in the details. We may approach the major or the main framework. Both the SFC and the government has carried out a lot of public consultation. But when it comes to the operational details, there may be certain hiccups, so to speak. Through the work of this subcommittee, we hope that we can fine-tune the requirements. But if we can only say yes or no to the whole lot, then does it mean that if the government accepts our suggestions, they have to go back and do it afresh? That won't be good. We have to bear in mind the efficiency of our deliberation. We have a deadline to work towards. So we hope that we can ask the administration to jot down all our good suggestions so that in one go in future they will have further revisions. So I just want to clarify with you, Chair, as to what we can achieve in the course of deliberation. Well, members have given suggestions and comments, and you represent different sectors, you represent your constituencies, and I'm sure your views are backed up by extensive consultation. I think the authority will jot down our suggestions, and they will try to see whether our suggestions are good and practical, and whether they can be put into practice. Maybe a legal advisor can put in a few words first. Thank you, Chair. Just now, a member asked whether the subsidiary legislation can be amended. Well, in accordance with Cap 1, Section 34(2), by means of a motion, we can amend the subsidiary legislation as far as we are sort of in line with the powers given to us. SFC. Well, I think we have got quite a few positive views. So any reply from the authority?
So my takeaway was 2 points of amendment that were suggested. One was the point about adding or email address, and the other was about considering whether a courier requirement can be incorporated. We will go back and think about this. We might consider putting it, making it, elaborating maybe or expanding it further in the code of conduct rather than in legislation. But we do recognize the concern, and so we will try and accommodate that. Address that.
OK， 或者
All right. Let's continue with the cross scrutiny. Please consider our suggestions seriously.
應該去到第6條啦。
Okay.
I think we are on Rule 6.
Clause 6 is a provision which essentially requires an issuer to give a confirmation to a holder of uncertificated securities whenever there is an amendment made in the register of holders relating to that person. The rationale for this is that today, when a registered holder has his holdings increased, he will receive a share certificate. So going forward, there will no longer be a share certificate, but there will be an update on the ROM. So the idea here is to make sure that the registered holder is properly notified that the ROM has been amended to reflect his holdings. So this obligation is incorporated for that purpose. So subclause 1 deals with the scope of the application of the provision. So it talks about where the issuer is effecting a change in the register of holders, and the change refers to an entry regarding an uncertificated holding of a person or to any other particular of that person. Subclause 2 says that when this clause is triggered, the issuer must give a notice to that person regarding the change, and it mentions the information that the notice needs to contain is referred to in subclause 4. Subclause 3 talks about the time within which the notice must be given. So if it's electronically, it must be within 1 business day, and if it is in hard copy form, 3 business days. Subclause 4 talks about the information that the notice needs to include, and that includes a confirmation that the change has been effected, which means that it has been recorded on the register of holders, the details of the change, and the date on which the change was effected. A point to note is that this notice would probably would be sent in a number of scenarios, including, for example, when there is a transfer, when there is a dematerialization, when there is a subdivision or consolidation of securities, anything that affects the record in the register of holders of a holders holding in uncertificated securities.
我哋停一停，譚岳衡議員。
这个谢谢，不好意思。
Dr. Tan Yueheng, excuse me. I took up much time to talk about uncertificated securities. I would like to make a few points still, however. We're looking at an USM regime. We should move towards paperless. This is a trend. Since we are implementing a USM regime, if we are still mandate or allowing paper notices, I don't think it's right. We haven't talked about Clause 7, but I want to touch on Clause 7. It is actually similar with the inspection of register. One can only go during business hours. We're in a modern era. Can't we check the register during off hours? Why do we have to go during business hours? And it says that the inspection must be at least 2 hours per day. Aren't we going paperless? What's the point? This is just a comment. SFC representative.
Comment and question. So the point about still allowing paper, as I mentioned, the reason we need to allow for paper is that we need to allow for the population of registered holders which have not yet dematerialized their securities and have not set up a USI facility, and therefore there is just no other way for the issuer and its agent, the ASR, to communicate with them. So I think the paper option needs to be kept. As to whether we should encourage the electronic paper, the electronic option, we do intend to do so. We are doing so. We will go back and look at the ASR rules, and we can revisit making this even more clear or expanding on it to make it clear that where the holder is an uncertificated holder, the notice has to be in electronic form. I should mention also that there is a cost element to all this. And so from the issuer's perspective, actually, it is actually cheaper and more cost-effective to send electronically. So where they have the option to do so, they would naturally do that. But we will go back and look at the ASR code again to make sure it's properly and clearly set out. Your second point was on the inspection. The inspection provisions are cast by reference to the existing inspection provisions in the company's ordinance. Given that some of the listed companies are also Hong Kong incorporated companies, we felt it would be better to sort of align our inspection requirements. The 2 hours per day requirement we think is reasonable. I'm not sure if the member is suggesting that we need it to be longer. If the concern is that it needs to be longer, we can definitely go back and revisit that with the share registrars. The point about during business hours, the idea is that the register of members is not going to be a register that is sort of available online, that anybody and everybody can access. That is not the intention. We would perhaps also need to think about whether that poses security risks if that register of members is so readily accessible. Apart from inspection, there is in Rule 8 a provision for requiring copies of the register. So a person is not necessarily required to go to the share registrar's office to physically inspect if during business hours. There is the other option of writing into the ASI and saying, I want to have extracts of whichever entries they are interested in, and that would be under Rule 8, and get that extract from the ASR, and there would be no time limit in terms of a 2-hour day or business hour restriction if that option is pursued.
我諗其實即係對上有
I think several members raised concerns, especially Dr. Tan Yueheng raised some points that are relevant in the sense that we have been developing the USM regime for 10 odd years. I think their points raised may be beyond the scope of the clause-by-clause examination, but I think for the government or the regulatory body, we should keep an open mind. We are not doubting the actual contents of Clause 7, so to speak. But then I think if it is a reasonable request, you should facilitate investors' requests and make use of technologies to do the same thing. I think it may be a policy-related question, but since members raise such concerns, we should have the administration note such concerns. Any response from the administration? The speaker's microphone is not on. I think members have raised some very good suggestions. I would like to say in particular for Clause 7, the 7th rule. It may not be the holder of the securities. It may just be a general member of the public. So this is just a basic requirement, what is said here. Of course, we did say it has to be, say, available for at least 2 hours per day, and the inspection would have to be made during business hours. So this is just a minimum requirement. As for what the issuer actually does, it will be a different matter. We hope to make sure in our code of conduct, not only the minimum requirements will be met, but to realize the vision of the USM regime. But please understand that it will take time, and we need to strike a balance. We need to balance also the needs of certificated holders and uncertificated holders. We may still have some traditional methods still to accommodate these individuals, certificated securities holders, but we are moving digital, and some of that may not be included in legislation. We will communicate with the SFC on this, and we will review the suggestions later. Mr. Ring Kong, I want to ask about Clause 6, Rule 6. I think this rule is very important because with any notice of change, and where uncertificated holding is involved, notice of change must be given. So it may include, say, change in name, deletion of name, or relevant information. I want to ask about Sub-Rule 5 in particular, an issuer that without reasonable excuse contravenes Sub-Rule 2 commits an offense. Can the administration elaborate on what constitutes reasonable excuse? In Sub-rule 6, I also have a question for this sub-rule. So, you say one may commit an offense when one contravenes sub-rule 2, but then when one makes a change, there may be several transactions with an issuer. What will count as one offense? Will it be counted as in batches, or is it individual transactions, or is it a single deletion would be an offense already? We have a fine at level 4. If a deletion would be constituting a single offense, or is it that what is done within a day would be counted as one offense? The SFC representative, please. Thank you.
Was about what would constitute a reasonable excuse. I think the first point to make is that whenever there is a change in the register of holders, whenever somebody requests a change in the register of holders, it would be in the context of largely a transfer. Another possibility would be a dematerialization, but dematerialization is unlikely to affect their actual holding. So transfer would be the most likely scenario where there's possible dispute, or where there's a possible misentry, if you like. The share registrar and the issuer, being disinterested parties, would basically act on the basis of information they have received. If they are not making an entry which one party to the transfer is requesting, it is likely that they would have concerns about the transfer itself. It might be that the certificate produced is fraudulent, or they regard the certificate as being fraudulent, or whatever. My point being that there would be some reason why the issuer or its agent, the ASR, has not made the entry. If there is that, and that would give them, the grounds to argue that there's a reasonable excuse. If there actually is no reasonable excuse, if they have just fraudulently or just for no reason not made an entry, then that offense should rightly kick in. So the reasonable excuse is really where there is a reason why they have not made the entry. Either is because they genuinely have concerns about the transfer, for example. It may also be a systems issue, for example. There might have been a bit of a delay, or there might be some hiccup somewhere, and so they haven't made the entry yet, but they are acknowledging it and they're taking steps, or maybe there's been some delay as a result, but they have some reasonable excuse as a result. I mean, obviously they have to demonstrate that the system issue was a reasonable issue to have arisen, and which gives them an appropriate, reasonable excuse. But these are the kind of scenarios that would arise, or we would expect to arise.
有冇答到你問題？
主席，我有個追問。
Has it answered your question? I have a follow-up question. On the question of systems, if the fault lies with the issuer system, if they could have upgraded the system in the first place, will it not be seen as a reasonable excuse? Well, if there is power outage and the system is out, that makes sense. But if the fault lies with the system itself,
There's control, then it would be a reasonable excuse, like a breakdown, a shutdown in electricity. But if it is something that's within its control, then it wouldn't be. But this is something that the court would decide, right? I mean, a lot of the provisions have this kind of a qualification. This is not unique to our legislation. So it would be for the court to decide whether the reasonable excuse has been made out.
OK， 下一位簡慧敏議員。
唔該，主席。
Ms. Kamen Khan, thank you. Chair, we are going through the clauses clause by clause. When we talked about Rule 5, some members suggested we should include an email address, but in Rule 6, we have seen with changes, issuer has to notify the holders, especially for uncertificated securities holders. I don't really understand what the SFC representative said about 6.2. Why it allows both options for the issuer. So the paper option is retained for certificated securities holders. I don't really understand why it is included, because this set of rules is USM rules. So it is about USM uncertificated securities holders receiving notices. We have several members raising concerns that we should move towards a paperless regime, and actually paperless regime. And we have uncertificated securities holders opening USI facilities only. We wouldn't have certificated securities holders doing that. That's what I want to say. So why do you need to offer a paper option for issuers? So issuers can opt for either one. I think it is exactly why Dr. Tan raised this point. And as Mr. Yim said, what happens if the notice is not received by the holders? So why not just send the notice in electronic form via email, so that the notices can be sent via email? Why offer another option? Unless the option would be for USY holders. If they want paper options, then this should be all right. But then this option is actually offered to issuers, not the USI account holders. It's like the issuer can opt for either one for uncertificated securities holders as well. Chair, honestly, I did not expect such detailed examination of the clauses when I became a member, but then we're actually implementing the amendment ordinance in 2021, right? I hope the administration can keep an open mind, because many of the members come from the securities sector. I just don't understand why you're offering a paper option still. Is this the right thing to do when the option is just for issuers?
Question. It's actually a very good question. The reason there is a paper option is because uncertificated holdings can be held by two types of persons. One is a system member, and one is a provisional system member. And the difference between them is that the provisional system member has actually not completed the process of setting up the USI facility. So they actually may not have given an email address to the issuer that the issuer can use. So when we spoke last week about the definitions, I don't know if you remember, we talked about system member and provisional system member. So the provisional system member is someone who receives uncertificated holdings, uncertificated securities, but has not yet set up an USI. So for example, he holds shares in paper form. The issuer is now a participating issuer. It is distributing bonus shares. The bonus shares can only be in uncertificated form, so they will be given to him in uncertificated form, but he has not set up a USI facility, so a temporary or provisional facility is set up for him, and his holdings are still uncertificated, but the issuer still has no email address for this person. So although the provision is limited to securities that are held in uncertificated form, there is still a possibility that you have a person whose email address is not with the issuer.
Thank you for further explaining the operation. But then as far as the law, as far as the rule is concerned, we can't tell how it operates. Well, in this case, would you agree with me that if the USI facility has already become operational, then email would be the only option available? Only in the case that when email is not available, then the paper form will be kept. In this case, it will be clear to us. In other words, if I have yet to successfully activate the USI facility, then I will be sure that I will get it in paper form. Then I can tell whether the transfer has been successful and whether I'm receiving the bonus shares. Well, in the case of already having USI facility, it means that I should expect a confirmation notice electronically only in relation to my uncertificated holding. I think at the end of the day, we want to be as electronic as possible. If you're still allowing options, then people may opt for non-uncertificated ways or forms that are not electronic. Well, not only is a question of going paperless, on the other hand, it is a matter of certainty. Well, if I'm going electronic, then I don't have to argue with you that I'm not getting it, and the issuer also won't be bothered by disputes as to whether it has been posted. So I think that can add to the certainty as well. Government, SFC, is it possible to further tighten up the scope so that you are providing electronic options as much as possible?
The reason we didn't make the distinction is because we wanted to leave the option to the investor, and through incentives and disincentives, sort of drive the investor towards going for an electronic option. I think we are more than happy to, in fact, everybody wants the increased use of electronic rather than paper. It's in everybody's interest to do that. But there may be a small population of people or investors who still want to get their communications in paper form for whatever reason. And we didn't want to sort of, deny them that option. But it would not be an easy option. I mean, easy in the sense that they would need to wait longer. For example, they would take 3 days, and there would probably be a cost attached to it. So like you say, like you will see, there's nothing here that talks about this having to be free. So the share registrars can easily, through cost incentives, sort of persuade investors towards electronic options. But we are also very happy to sort of limit the options altogether if that is the preference. We can do that in the legislation itself. We can do that in code or guidelines. We're happy to consider that.
嗱，主席就住呢個回應呢，意嘅呢就係呢個。
Well, it does say that it is free irrespective of the form. The issuer must provide this notice, and then the option doesn't, the choice doesn't lie with the investor, rather the issuer. It's an option for the issuer to pick. So if you give the options to the investors, I think that's better, so that even if it is a case of uncertificated holding, an investor may still want to get the notice in paper form. But in fact, to me, I think the option lies with the issuer. It's the issuer that can make a choice. So please reconsider it. Please continue with the cross scrutiny, Rule 7, I think, SFC.
So Clause 7 is the inspection of the register. This has been cast by reference to Section 631 of the Companies Ordinance, which also deals with inspections of registers of holders, as well as provisions of the subsidiary legislation on inspection under the Companies Ordinance. So Subclause 1 deals with the person's right to inspect. The right is limited to persons who are registered holders. It is not extended beyond registered holders. Having said that, many registers, especially company registers under company legislation, are open to public inspection. We have not included that element in this legislation because we didn't feel it was necessary for the purposes of USM. And if public inspection is permitted under the underlying law for the relevant securities, that's fine. If it's not, that's also fine. We didn't want to dictate it one way or the other. But we did want to make it clear that at least the registered holder should have the right to inspect. So Subclause 2 deals with the timing, so the inspection must be during business hours. Subclause 3 clarifies that the scope, if you like, the limitations on inspection. So if the register is closed, then it wouldn't be made available for inspection. And there may also be reasonable restrictions, but whatever restrictions there are, the register must be open for at least 2 hours a day. Subclause 4 deals with the making of copies during an inspection. So the idea is that when a registered holder comes to inspect the register, they must be able to make copies, but there is no obligation for the issuer to assist them in doing so. This clause is similar to provision in the company's registry, the company's ordinance, subsidiary legislation on inspection. And then subclause 5 deals with contravention being an offence.
係江玉歡。
Ms. Doreen Kong, thank you, Chair. A quick one. My question is, so under 7.1, it talks about a person, anybody. In other words, it would include if somebody has died and then the intended executor and the lawyers can also approach the register and have an inspection. Am I right to say so, SFC?
My take is that it should, because the executor or personal representative steps into the shoes of the member. But if you will permit me, I will go back and check that to be sure.
Thank you.
好，check 咗之後，
Yes, please inform us after you have checked it. Next, Mr. Tan Yueheng. Thank you, Chair. Thank you, Chair. For Rule 7, as I have mentioned, other than the business hours, I just wonder whether we can do so online, whether the register can be uploaded online so that the holder, by inputting his password, then he can check the register to provide convenience for the inspection so that the holder can inspect the information at his own convenience. Now, clause 8, we haven't started that, but excuse me, I want to go there. Please wait. I just want to include that as well. Yes, please. It talks about 10 business days. That is, after the holder has made a request, it will be 10 business days before the issuer will provide the information to the holder. In other words, sometimes a holder may be engaged in a legal litigation. He may need some proof. It will be an urgent case, and yet you make him wait for 10 business days. Can you not provide an alternative to speed up the process? Say, for example, by adding a sort of additional cost to get it quicker, SFC.
Thank you for those questions. So, on the question about whether why the investor can't inspect at any time, actually, as far as an existing registered holder is concerned, if they are holding an uncertificated holding, they will actually have full-time access to their portfolio. In fact, many share registrars, even today, they have this service for registered holders, where they provide an online facility where the registered holder can view their own holdings. So I don't know if that would address your question.
即係我諗個意思就係話。
I think what he meant was that if a holder I think the point is the share registers can already provide the information online outside the business hours. My understanding is that here you talk about non-investors, or there are other persons who may have a reason to check the information, and in such a case, then you can only do so within the business hours. Is that right?
There's maybe a slight difference between inspecting the ROM, inspecting the register of holders, and checking your own portfolio. But because your question, as I understood it, was that the 2 hours per day and business hours may not be convenient for everyone, and you were suggesting to therefore put the entire register of holders online. So rather than rather than putting the entire register of holders online, another option would be for the investor who, assuming he is a holder of uncertificated securities, because he would have online access via his USI facility to view his portfolio at any time. So that would go to some way to checking the ROM, if you see what I mean. But of course, it's not exactly the same as checking the ROM. I accept that. But what I'm trying to say is that if there is an urgency for that individual to check his holdings, to view his holdings outside of office hours, he will actually have a platform to do that.
说我们还
I want to say that we would still encourage listed companies who have the means to provide electronically the registrar's access to upload the register online, so that investors can check at any time the register. It will not be limited by the 2-hour requirement. Well, any more supplementary information to be provided by representatives of the administration, I think the SFC representative said many investors can access some information online during outside business hours. And on Clause 8, because Dr. Tan Yueheng also asked about Clause 8, the 10 business days may be too long for lawsuits or emergencies. Is it possible for one to expedite the process by paying a fee? Is it possible?
Registrars would offer services for speedier services. I mean, one option is for the legislation to set out all of this. The approach we're taking is that this is a baseline service level that we expect. So if the share registrar wants to offer more expedited services for a higher fee, it's entirely open to them to do so.
即係實際操作上應該就係
I think in operation, this is just the minimum in the provisions. There should be some way to provide more speedier access of information. I have some questions on Clause 7 myself. Like Dr. Tan Yueheng said, for inspection of entries in Register of Holders, if one makes a request, the inspection should be available free of charge, but you have a 2-hour requirement here. So, issuers, if they make use of a lot of resources to meet the inspection requests, 2 hours may be already too long. So how did you reach the figure of 2 hours? Well, let's first deal with these two questions. What does the SFC think about the 2-hour requirement? How have we struck a balance between the cost on issuers and the rights of those accessing the information?
2-hour requirement really comes from this company's ordinance, because like I said at the outside, we have drawn reference to the company registry ordinance. We did not want to go beyond what was necessary for USM. The second question was about balancing the right of public access and the registered holder. So, as far as we're aware, for shares, the companies, at least in the case of Hong Kong companies, the register of members is open for public inspection. For OFCs also, it's open for public inspection. We're not sure whether for all of the securities listed on the SEHK, there are similar provisions, especially those listed overseas, incorporated overseas. So we didn't want our legislation to go beyond what is necessary for USM. And so when we designed this, when we were casting these provisions, our focus was on what is absolutely necessary. And we felt that at a minimum, the shareholder who no longer has a certificate should be able to inspect the register of holders if it wishes to. But we didn't see a need to expand that to go beyond the registered holder for the purposes of the USM regime.
Okay. 好，下一位江玉歡議員。
主席，我想請問一下呢。
Mr. Rincon, I have a question. We have many penalties in the provisions that would be a fine at level 4 and a daily fine. There's no daily fine in clauses 7 and 8, Rule 7 and 8. I understand for Rule 7 for not imposing a daily fine, but for clause 8, we have imposed a period. So why have you decided for some that you would need daily fines, for some you wouldn't?
Company ordinance provisions, we didn't see any need to differ from the company law provisions. So the company law offences for inspection do not have a daily fine, and nor do the provisions on copy.
主席，我呢度想俾個 note 啫，我唔係要講。
Chair, I just want to provide some notes. I'm not asking for this to be amended. I think this is not ideal. I would raise similar questions on other provisions. If we have for some provisions, daily fines, for some provisions, no daily fines, I think it can be confusing. I do understand what Ms. McAdam said about referring to company's ordinance, but I just think for some provisions it would be hard to implement the daily fines. All right, thank you. Let's proceed with the clause-by-clause examination. Well, any other supplementary information relating to Rule 7? If not, we can move on to Rule 8. 好，喺第8條要求
This is again cast by reference to the CO equivalent provisions. Subclause 1 confirms the right to get a copy on request and payment. Subclause, sorry, I beg your pardon. So the copies must relate to an entry made in relation to that person, and it can include historical entries. Subclause 2 clarifies that basically the idea is that there must be sufficient particulars provided to the issuer in order to make the copy available. So if the person requesting the copy has not provided sufficient particulars, the issuer cannot then discharge its obligation. And so subclause 2 is really just to clarify that the request needs to have sufficient particulars. And of course, because there is the ability for the issuer to destroy after 10 years, so the obligation to request for copies should not cover records that have been lawfully destroyed. Subclause 3 deals with the time and the payment of a fee, so it talks about the issuer having to provide the copy within 10 business days and upon payment of the specified fee. Again, we have the option to do it in hard copy or in electronic copy per the request of the person in question. And subclause 4 makes it an offense to breach this provision. Subclause 5 are definition provisions, so it basically just defines what is meant by electronic form, and we do that by reference to the ETO. Defines hard copy to mean paper, and it expands on what is the specified fee. The rates we've put in here are again by reference to the company ordinance rates.
我哋而家有提問就係江玉歡議員。
All right, we have some questions. First, Mr. Rincon. I would ask Ms. McAdam to refer to, say, for person in Clause 8, would it include the intended administrator or the legal representative or executor? I want to ask about Clause 2B. In English, it contains the term governing provisions. Is there a definition somewhere? Because I refer to the relevant ordinances, it is not found, the definition. Why do we have this here?
Question, there is a definition. I'm just trying to dig it out.
或者係先生係咪有嘅
I think an other official would be able to provide some information. Well, it is in clause 2 of the USM rules. It is in the USM rules that we are actually scrutinizing at the moment in Rule 2. In Chinese, it would be 管限條文. Thank you. I think that answers your question. Next to speak, Ms. Carmen Khan. Thank you, Chair. I want to ask about Sub-Rule 5. There is a definition for electronic form. There are also definitions for hard copy form and specified fee. But these definitions are only limited to Rule 8, right? Or is it for other rules as well? Because in Subclause 5, it does say specifically in this rule. So say in Rule 6, we also said if there is a change in register of holders. We also talked about sending notices in electronic form and hard copy form. Why do we only have the definitions in this rule? Mr. C, you have some explanation. The definitions only apply to Rule 8. So the definition of specified fee is only applicable to Rule 8, but the terms electronic form and hard copy form are also found in Rule 6. Why have you not defined these in Rule 6? Why do you define these only in Rule 8? Do these definitions apply for the whole of Part 2? Or maybe even the whole USM rules? I hope the Assistant Legal Advisor understands what I meant. Why are these definitions only limited to Rule 8? Because I think these terms appear in LN 15 at different places. Why do we need to define this in Rule 8? I think Assistant Legal Advisor has something to add. Well, I think with the current drafting, the definitions only apply to Rule 8 because it is only found in Sub-Rule 5. As for whether we need a general interpretation in Rule 2, I will leave it for the administration to decide. Thank you. I think these terms appear elsewhere in the USM rules. I think we should put that in Rule 2 for the general interpretation, not just in Rule 8. Well, let me explain why it is drafted this way. As Ms. McCardam said, we have actually referred to the company's ordinance for drafting this provision. And in 622I section 11, they have defined electronic form and hard copy form in the relevant section. We have basically just copied that section to Rule 8. As for in other rules, there are also these terms. Whether the definition should be made applicable to other rules, I think this is something we can consider. Whether to make amendments in this regard to move these definitions to the general interpretation. We will review this internally after this. Thank you. I think the administration can really consider this because these terms appear elsewhere in the rules, we can perhaps move the definitions in to Rule 2. Right, because these terms do not only appear in Rule 8, they appear throughout the LN 15, so I think we can really think about that to make the drafting better. All right, please proceed with the clause-by-clause examination.
Clause 9, which is the limit on the closure period for the register of members. So normally companies' legislation allows for the closure of a register of members, and there is a limit of, in many cases, about 30 days per year. we wanted to restrict that right a bit more in the USM environment. The reason is that if we close the ROM for too long a period, it will prejudice investors who hold securities in their own name outside of CCAS. So we have included this clause, the main purpose of which is to limit the closure to no more than 2 days, or if it's got to be longer, then it has to be a period during which trading is suspended. So subclause 1 talks about the scope of the application of this rule. So it applies to the register of holders of whenever the register of holders can be closed under the applicable law or their own governing provisions. And secondly, the securities are participating securities. So we're talking here not about, we're talking here only about securities that have become USM enabled. Subclause 2 talks about the actual restrictions. So it says that it cannot be more than 2 consecutive days or any longer period during which trading is suspended. Subclause 3 talks about the Commission's ability to exempt this obligation. We have included this exemption power really just for flexibility. We do not actually envisage, we do not actually have a specific scenario in mind where we might exercise this power, but because it's a new area, we wanted to leave that flexibility open in case it did become necessary. But the prerequisites for any such exemption would be that none of the securities are actually in uncertificated form, which is probably quite difficult to be the case. But I think that would have to be, because if any of the securities were in uncertificated form, it would be difficult to meet criteria 2, which is prejudicing investors. So for that reason, we have put both those criteria. We can come to how this can work if it becomes absolutely necessary. The reason is because the provisions in the legislation which prohibit the issue of certificates and the use of titled instruments, there is an exemption power for that as well. And so in the very highly unlikely and extreme scenario where we do need to allow for a book closure for some reason, we could reverse what has happened. But I have to emphasize that, number one, this is not what we are encouraging. It is a highly unexpected and exceptional situation, which in fact we cannot even imagine today what that situation might be. But we wanted to leave that flexibility just in case it became necessary. So Subclause 3 goes on to expand on the power of exemption to talk about, imposing conditions, amending and revoking the exemption and the conditions. Maybe I pause there to see if there's any questions on that clause.
OK， 可以繼續嚇。
Right. Then I move on.
You may continue.
10 is, again, modeled on a CO equivalent provision, which is the court's right to rectify the register. Any person can apply to the court for rectification if they feel that their name is without sufficient cause entered or omitted, or if there is any delay in entering their name in the register, or removing their name as having ceased to be a member, and also any record which they feel without sufficient cause has been entered or omitted regarding the number of units held and the number that are in uncertificated form. So the person who may exercise this power are basically persons who are aggrieved. So this may or may not be a registered holder. So a registered holder may obviously have concerns that their entries are not accurate, that it doesn't accurately reflect their holding. An aggrieved person may be somebody who feels that the register should reflect their holding, but it doesn't. And the third party is the issuer, who may want some rectification. This is possible because it might be that an entry has been made, but it cannot be corrected without the court's assistance. Subclause 3 deals with the powers of the court. So the court can, on such an application, refuse the application or make an order to rectify the register, or make an order to, on the issuer to pay damages. Subclause 4 deals with what the court needs to consider when determining an application. Sorry, not what the court needs to, but what they can decide. So it clarifies that the court can decide any question relating to the title of any person who is a party to the application. And it can also generally decide any question necessary or expedient for the rectification. Subclause 5 talks about the extent to which this rule applies. It just clarifies that this rule applies only to the extent that the application is not prohibited or in conflict or inconsistent with any other laws. So the provisions that are set out there by way of example are provisions of wrong rectification that already exist in our legislation. So that is just there for reference.
江玉歡議員有
主席。
Ms. Doreen Kong, yes, just a quick one. Under 10.1, I want to know whether it covers the following scenario. That is, a person's name is not correct. Here you only talk about omission of the name. But what about if the name is not correct? What about if a name incorrectly entered? Can it be rectified via such a request, or whether under the company ordinance we can already do that and it's an easier one, a quick one? And what about persons that can put in a request? Any person aggrieved, would that cover the following? That is, under mental health ordinance, his guardian, or what about an executor? Would that be covered?
Thank you for the questions. So the first question is about what if the name is not correct, I think you were saying. So I think there is a distinction between correction and rectification. So if it is actually an error, it is open to the share registrar to make the correction. So if it is satisfied that the name is incorrect, misspelled, or whatever, then that's fine. But if the share registrar or the issuer does not agree that it is simply a correction, then you would be able to say that the name of the person is without sufficient cause omitted. That would be the logic.
Okay. 即係主席，即係話如果錯名咧，就淨係。
In other words, it would be the share registrar that can correct it.
第二個問題咧，請問係。
Yeah, so the second question was about who's the person aggrieved. So one possibility would be a transferee. A possible transferee would be an obvious one. You also asked about the mental persons who have guardians appointed. I think there is separate legislation that deals with that. We have, I believe, a mental health ordinance, something, yeah. So I think separate legislation deals with the rights of the guardians to step into the shoes of the person involved.
我明主席，咁即係唔緊要，嗰個當然有嗰個ordinance 啦。咁我即係 make sure 咧，其實即係。
Well, I just want to make sure. Say, for example, a person is already covered by an order, and then there's a guardian. Then the guardian will step into the shoes of the holder. So does it mean that the guardian will be regarded as the person aggrieved?
Correct. That would be my understanding.
Thank you.
簡慧敏議員。
Ms. Carmen Ken, may I ask a question about 3B? 3B is about what the court may do. It includes making ratification and making an order to pay damages for any loss sustained by any party aggrieved. That's the duty of the issuer. Why is it confined to the issuer? Could it be the case that the ASR that commits the mistake? So I think that is in line with the question asked by Mr. Tan Yue Heng. On the face of it, the law is about asking for a register to be kept, and you need to make entries. Now, if a problem, if there is an issue, it seems that all such will be the liability of the issuer. But what about the ASR? Or would you leave it to the issuer and the ASR? Would it be the case that the issuer is fined by the court, say for example, and then the issuer will go after the registrar for compensation? So what's the rationale?
So that's correct. So it would be a matter for the share registrar to follow, for the issuer to follow up with the share registrar. I think the point to emphasize in this context is that the ASR is always acting as an agent. The ASR is not acting as a principal at any point in performing its roles vis-à-vis the Register of Holders. The Register of Holders belongs to the issuer because the register reflects holders of the issuer. So the Register of Holders belongs to the issuer. The obligations are therefore also imposed on the issuer. The ASR's role vis-à-vis the register is really as agent of the issuer. So if there is an award ordered against the issuer, and it's actually due to some default of the ASR, then it would be a matter for the issuer to follow up on with the ASR.
係主席，嗱，咁我明白。
Yes, appreciated. It is the issuer that is the principal. But then later on, we'll also look at the ASR rules, and I hope that there is a balance. As far as regulatory work is concerned, we must impose appropriate sort of duties on the ASR. Otherwise, it is unfair to the issuers. I hope we can address that later on. It's approaching 11 o'clock, so maybe we can cover Rule 11 because there are just 2 paragraphs. So maybe we can adjourn after clause 11.
The effect of entries on the register of holders, and essentially it basically says that if there is an entry in the register, it is in the absence of evidence to the contrary, it's proof of the matters entered. So this is similar to what is already in the company's ordinance. Sub-rule 2 talks about the uncertificated holdings, and it reflects that a record indicating any number of units in uncertificated form is proof of the person's title to that number of units. So we felt it would be useful to have an additional emphasis for the uncertificated holdings given that there's no longer any certificate. That's why we've added the subclause 2.
OK， 咁我哋而家就快接近11點鐘咧。
It is approaching 11 o'clock. And we have scheduled our meeting to end by 11. So let's talk about the dates of our future meetings. The Secretariat has already reserved the following time slots: 24th of March, Monday, 2:30 till 6:30 p.m., as well as the 25th of March, Tuesday, between 2 and 4 p.m. So the following item, AOB, anything under AOB? If not, then I would say that meeting is adjourned. Thank you.